House Bill 6160 by Chairman Craven. It's, bless you, it's an act relating to property, Residential Landlord and Tenant Act. It grants tenants that are the victim of various forms of abuse, including but not limited to sexual and domestic abuse and stalking, the right to terminate a lease agreement early without penalty or liability for rent. So, Savannah, come on up. And let's see, Lucy Rios and John Wesley? Okay, sorry. I'm getting there.
Thank you for your patience.
Yeah, sorry about this. I didn't know. Savannah, you want to start? I know you have a young child outside.
Sure, thank you. Good evening. My name is Savannah. I'm a mother, a survivor of domestic violence, and a proud member of SOAR, Sisters Overcoming Abusive Relationships, a survivor task force of the Rhode Island Coalition Against Domestic Violence. I am here this evening in strong support of House Bill 6160, the Survivor Early Lease Termination Act. In December of 2015, my abuser was arrested and removed from our apartment. I immediately reached out to my landlord for assistance because I needed to ensure my safety. However, my landlord refused to let me change the locks, denied my request to terminate the lease early, and told me I could not make any changes to the apartment without signing a new lease, even though the current one still included my abuser's name. I was already facing a difficult situation. I was struggling to make ends meet, and I knew it was unlikely I could ever cover the rent and utilities on my own. I had received notices threatening to shut off utilities, and I was falling behind on rent payments. To make matters worse, my abuser, despite a no-contact order being in place, used his key to enter the apartment again. When he was arrested once more, my landlord finally agreed to change the locks, but only if I was able to pay $150, a fee I simply couldn't afford. The financial strain was suffocating. I was scared, uncertain of how I would keep my home, and at times I even considered letting my abuser back in just to avoid losing my apartment. By April of 2016, I was served with eviction papers. To make matters worse and even more overwhelming, I had just found out I was pregnant. I was terrified and didn't know where to turn. I showed up to court anxious and without a clear understanding of what to expect. The landlord's attorney offered me a deal. If I vacated the apartment within 20 days, I would only have to pay back rent and legal fees. If I didn't agree, they warned me that a judge might impose harsher consequences. I didn't want to risk a worse outcome, so I reluctantly agreed. But I felt I was left with no choice, no options, and no way for a fresh start. After my eviction, I was homeless for nearly 5 months. More than half my pregnancy was spent worrying about where I would sleep, how I would keep myself safe. I was living in survival mode, unable to focus on preparing for my child's arrival. In October of 2016, I was able to find roommates and secure a temporary place to live. But it wasn't a solution. I was constantly reminded that this was only temporary. When I began applying for housing, I was repeatedly denied because of the eviction on my record. The first time I was denied, I felt too defeated to appeal. I wasn't familiar with the process, and it seemed like a hopeless fight. But after a few years, I tried again, this time with the support of advocates and social workers who helped me navigate the appeal process. Eventually, I was able to secure affordable housing. The road to recovery has been long and difficult, but I'm here today to tell you that no one should face these hurdles. The Survivor Early Lease Termination Bill would remove barriers for survivors like me by allowing us to safely and quickly exit dangerous living situations without the additional burden of financial hardship. It would protect survivors from the threat of eviction and offer a way to move forward, free from the control and fear of an abuser. This bill would give survivors the freedom to rebuild their lives, secure stable housing, and focus on healing and safety rather than struggling to survive. It is a vital step in ensuring that no one has to face the compounded trauma of domestic violence and homelessness. I urge you to support House Bill 6160, the Survivor Early Lease Termination Act, and to stand with those of us who are working every day to rebuild our lives and ensure a better future for ourselves and our families. Thank you.
Thank you, Savannah. And I'm glad you made your way through, but it sounded like a tough ordeal.
Thank you.
Any questions of this witness? Seeing none. Lucy? Oh, did you have a question? Rep. Cruz?
Yeah, thank you, Savannah, for sharing this story. It's a really great bill, and I'm really happy that it's before us, and you shared the story of the intersection of being safe and then dealing with your landlord, knowing you were in this dangerous situation, could potentially put your life at risk, but also, too, we hear a lot of landlord bills here about their property, too, and destruction. This actually protects from that, too. So, you know, thank you for sharing that story. It's very upsetting. They wouldn't let you out of the lease for even their own selfish reasons because they could protect their units, but your life and your safety. So I want to thank you for sharing it because it's an important piece to this legislation and getting it passed. So, and I was a member of SOAR a very long time ago, and so I just want to thank you for being here and advocating.
Of course, thank you.
Lucy?
Good evening, Madam Chair and members of the committee. My name is Lucy Rios. I'm the Executive Director of the Rhode Island Coalition Against Domestic Violence. I am here this evening on behalf of our network, Task Force of Survivors, SOAR, and our 10-member agencies to express our strong support for House Bill 6160, the Survivor Early Lease Termination Act. This legislation is the top priority for the coalition and our network, who served last year alone 9,661 individual survivors of abuse and over 300 children. So why do we need this bill? Well, you heard Savannah's story, and it's one story of one survivor's experience and the hardships that it caused for them. But survivors, many survivors in our state, may need to leave their homes quickly for their own safety, and the threat of financial penalties can prevent them from doing so. Continuing to pay rent on a lease survivors can no longer occupy, especially when they may be experiencing other hardships, can create additional barriers and financial strain on survivors and impede their ability to find safe and sustainable housing and rebuild their lives after abuse. This survivor safety bill will provide crucial protections for victims and their children fleeing abuse, domestic violence, sexual assault, and stalking. It will allow eligible survivors to terminate their lease early for safety reasons without incurring fees or penalties. It will make this process clear with required tenant victim documentation for eligibility provided to landlords. This bill will also enable survivors with the necessary documentation to be able to be allowed a lock change at their apartment at the tenant's expense. We've heard from many victims in Rhode Island who need these options to keep themselves and their children safe. A diverse coalition of Rhode Island survivors, advocates, and service providers came together to champion this bill based on similar laws from our neighboring New England states, all of whom already have this safe housing law. Key provisions of the Survivor Early Lease Termination Act include a prohibition on evictions, fees, and other penalties for abuse survivors who terminate their lease early to flee for their safety, a prohibition on landlords disclosing confidential information obtained from survivors, and a variety of methods survivors can use to verify their status with written documentation, including self-certification as found in other Rhode Island domestic abuse safety laws. 41 other states have early lease termination laws for survivors, with New Hampshire joining the list in May of 2024. 19 states have tenant lock change laws for survivors. Survivors of abuse who live in public housing or federally subsidized housing are already protected through the federal policies in the Violence Against Women Act, known as VAWA. VAWA was reauthorized in 2022 with updated fair housing protections for victims, and VAWA is considered the gold standard when it comes to defining housing protections for survivors. This bill will extend the survivor tenant protections covered in VAWA to private housing here in Rhode Island. VAWA allows survivors if requested, to provide a self-attestation that declares that they are a victim of domestic or sexual violence. This is important because there are many survivors who do not file for restraining orders or do not call the police for help after they've been assaulted, or call a domestic violence hotline or an advocate for support, or go to the hospital or a medical provider to have their injuries treated. Most abusers are not criminally charged or convicted. Many lease termination laws across the country allow certification by the survivor and/or by third parties such as domestic violence and sexual violence advocates, so that all survivors are covered by these protections. Survivors in Rhode Island deserve these protections. They deserve to be believed when they disclose abuse. I thank you for your consideration and urge you to pass this bill, and I'm available to answer any questions, and so is my colleague, John Wesley.
Thank you, Lucy. John Wesley?
Thank you, members of the committee. My name is John Wesley, also with the Coalition Against Domestic Violence. I'm really just here if the committee has any questions about any aspect or section of the legislation, having helped to draft it.
Okay, thank you, John. Any questions of either of these witnesses? Seeing none, thank you very much for your testimony. Next is Julia Keefe. Come on up, Julia. You're a Roger Williams Law student? Ah. Wow. Ever? So you're graduating? Whoa,
Yes.
congratulations.
Thank you so much.
We know how that feels, many of us on this committee.
Yes, I'm grateful to be here.
Go ahead.
So good evening, chair members of the committee. My name is Julia Keefe, 3L at Roger Williams University School of Law, here to testify in support of House Bill 6160. I'm writing in support of this House bill as it would be an important step in expanding domestic violence considerations in private housing. Many looking to flee abusive situations face significant barriers outside of the abuse that they are facing. There are financial, emotional, logistical, and even potentially criminal implications that could come from someone simply seeking safety. This bill is late in Rhode Island, in my opinion. It is important to note that 41 other states have early lease termination laws for survivors, and 19 states have tenant lock change laws for survivors. The consideration of domestic violence in private housing is critical because the federal policies in place, like the Violence Against Women's Act and the Fair Housing Act, do not adequately protect victims of domestic violence in private housing. Domestic violence is the leading cause of homelessness, and survivors face very limited options, as we heard, when looking to leave an abusive situation. Rhode Island has an opportunity today with this legislation to remove a heavy barrier for domestic violence survivors. I greatly appreciate your consideration and urge you to pass this bill this year. Thank you so much.
Thank you, Julia. Any questions of this witness? Seeing none, thank you all for coming forward. Domestic violence is a very important issue that we need to address, especially with housing. I used to be on the board of directors with the Elizabeth Buffum Chase House, and we had several, obviously most of the women in there had been victims of domestic violence and homelessness, and some of the women we had to hide. So it's a very important issue that and I feel for all of you and I commend you who are working on this issue, and those of you who experienced it. It's very difficult, but thank you for your testimony.